Hey, I'd rather be on mute because he could be leaving at any second here. So I'm going to mute the call. Okay. Okay, I'm going to log off. Bye. Heads up! Fellas, sorry to interrupt. He has just left the golf course. He's just left. He is en route. TRT approximately 50 minutes. I'm coming down and joining off. Ciao. Okay. Okay. Bye. No problem. Okay. Ciao, ciao. I rolled on it in the camera if the video broke up. Just let me know. But I'm coming down. Bye-bye.
Yeah. see? Oh, okay.
That was James. He's going to put you on live TV. So you stop putting this down. No, that's okay. You stop me down. Put it back up on that. He's going to run my own shot. They decided not to because they lost it. There he is. What's up, stranger? Yep. Okay, you want to see her again?
Folks. It's hard to operate this camera.
How's it going? Sorry, was trying to unmute myself. I saw two SUVs come in this way and I shot it. I don't know if it's him or not, but it's not. Yeah, it's too soon. Yeah, I'm on that side.
It's just painting. I don't know why.
Missing a glove, I guarantee him my poodle goes in and pulls them out of my pocket. I guarantee it's sitting on the ground right by my front door.
Probably.
Wherever I hang my jacket, he goes in there and pulls them out.
I cannot keep gloves unless they do this.
Oh, no, yeah.
Otherwise, I lose them immediately. And my mother got me a really cool pair of photographer's mittens that don't. And I'm like, oh, those are not going to last long. It's a good idea.
You know.
It's a very good idea.
Staple them to your ass.
No, I own a heavy-duty sewing machine. I don't know why I didn't think of that. All right, done.
I mean, really, I mean, he's going to take a right down there. I'm going to have a set up and take a right. I think there's one of them. Yeah, on the other side.
I thought he was yelling my name.
I'm sorry.
Yeah.
Yeah, no, I think that was
What did we learn?
That I need to wear a better coat.
I feel as though we learned this lesson a few months ago and then forgot the lesson over the break.
If you really want to press the issue.
Yeah, good coffee too. Yeah. And Dex, last time you said he came down this way?
We made the turn right at
Got it.
turn around south. That's if we got first
Okay. I shall plan accordingly.
I don't know who did it.
You know, the worst part is, even if he has his window open and he's hanging out of it, he'll be on the other side.
I mean, if he's driving, we've got a good shot.
Yeah, if he's driving with the front window open.
Yeah, then we're good. Or if it's a convertible.
Yeah.
Yeah.
I wasn't thinking about that.
Yeah. Like if he just pulls up by himself in a
JFK.
Miata, we got this.
It's like a JFK, a Lincoln.
I can think of one time when he did. No, a president.
Oh,
Maybe someone, just like they told JFK, you know what you should do?
Same with the
Take
Pope.
a convertible. It's so nice out. It doesn't look like they're prepared to shut this down.
Yeah.
Something in there, they can shut it up right there. This guy's gonna do that.
If we thought this out, we'd have APs up 4 streets of walking. Yeah, but just like that, a stakeout is making something like. Okay.
Yeah, we're gonna go tonight.
That good?
Beautiful day in the neighborhood.
That's why I guess yeah, I think they're going to go with traffic.
Yeah, well, I've been lied to before.
The worst weather of the year. Everything was well, except for Trump. Trump's last inauguration was a mild, the weather was mild. Oh no, they'll be getting rid of that. They'll be getting rid of that probably like first week, the last week of the month before the inauguration. That's going to be plenty. Only when you get one more by the inauguration. They don't want to go through credit because everybody else is going to do it. Then you will get some days off. They didn't think all of people would show up. I only got there. No, it wasn't. Yeah. Second one was cold. 5 was somewhat cold. Something was fine. There's nobody
like anywhere, but yeah, a little bit more. Yep, you guys are the best. Thank you so much. Don't get me wrong, I love the helmet shot. But it's not what you draw for. No. Back up so this guy can bring around.
Fucked off? Okay. Can I go up the ramp right there? Alright. Okay. Alright. Nobody can go in. You gotta wait about 20 minutes. Nobody's going in.
Nobody's going. What exit? Back down this way. You're welcome.
Sorry, I had to move to an iPod. A monopod. So I'm trying.
Not the solo part. Now watch my feet that way. Let me come this way. A whole bunch.
Everything's on D Street should be open. 3rd Street, north to south control.
That was it, right?
Yep.
Well, that was good and useless.
Yeah. Well, I mean, even if you could see it, it's not possible. Yeah. All I see is that line of vehicles. I mean, it's up to the network to complain. If they do. All right, I'm back on.
Okay. I am wide and long.
Yeah,
I'm gonna roll this stuff back to my truck.
I think I'm going to find out.
It's getting a little wet. I don't need these bags to get this wet today.
So, good. Thank you very much for the one-on-one interpretation. Yeah, that's it. Very good job. We'll do it I thought that, I thought you were doing it. I thought that you were doing it. Well, we were on
Quiet.
the whole time.
Oh, yeah.
Probably not. They're not letting anyone. Like I said, I just got tired of the future.
Yeah.
I think what they're doing down there. I don't think anyone's going to be allowed on the sidewalk except on my phone.
have everlasting life. Let me remind you also, we make America great again by making America godly again. While Donald Trump has sat and watched everybody suffer, I have spent the last 5 years of my life restructuring and rebuilding this interior. By what? Standing up, regardless of time, place, or circumstances, and reminding our enforcers of what their job is. I remind you of the law because I know law better than all of you. Now, where is he at? Almost time. So he goes right in this area. Oh, by the way, if you want a one-on-one, I'm staying at the Beacon Hotel and corporate offices. You can come sit down for an in-depth one-on-one. Unlike everybody else, I don't believe in expanding on a fictitious entity like the Hilton pedophile and all of these other conglomerates. Very soon, we're going to host a rally outside of Trump Tower. Now, where is he at? You want to talk about a political prisoner? Let's go back to 2007. Let's go back to World War II. Where methamphetamine was first perfected. By what? Who? Adolf Hitler, right? Let's talk about World War II, shall we? Let's talk about everything that actually matters. Because the only thing I see on CNN, MSNBC, and all of the affiliates is the same bullshit. You want to bury Trump's name from any association to Epstein Island? No. I'm going to reaffirm it. Donald Trump is a pedophile. And Justice Clemens will recuse himself. I will be front and center at the United States Supreme Court tomorrow morning, calling for the immediate boycott of Justice Clemens. Whatever the fuck his name is. You know, the black guy is married to the white woman. The same white woman that planned the so-called coup of the United States Capitol. The difference is, I come with documentation and proof beyond a reasonable doubt. I walked from the account over the side and avoid all the media attention. That's okay, because I'm going to document that I was here, and then I'm going to go back and I'm going to prove how much of a coward Donald Trump is. My entire goal to eliminate Donald Trump. This council is appointed by current President Joseph R. Biden. Where's he at? I'd like to make a grand with him. I got the running you see now. United States. What's that?
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3228, United States of America versus Donald J. Trump, appellant. Mr. Sauer for the appellant, Mr. Pierce for the appellee.
Sauer, good morning. Before you get started, can I just get a couple of things on the record? Our jurisdiction was challenged by an amicus, but from your reply brief, you are not questioning our collateral order jurisdiction.
Correct. We defend the collateral order jurisdiction. That's correct, Your Honor.
And then also, you have either abandoned or not made the Fifth Amendment double jeopardy argument before us.
We have framed the double jeopardy argument as arising principally from the impeachment judgment clause. So we haven't argued that if you go straight to the double jeopardy clause, that alone would result in reversal. We're focusing on the impeachment judgment clause. Now that incorporates principles of double jeopardy, right, but we haven't said a straightforward directly under the double jeopardy clause in this court at this time.
Go ahead, then.
Well, before that occurs, then I do want to speak to you a little bit more about jurisdiction, because we still have to satisfy ourselves that we have the jurisdiction. So an asphalt still applies.
Yeah, not presidential in its respect. This court's
You're making your decision.
right. And well, what I would say is this court's decision in Cisneros explicitly says, and you know right there, and it says most separation of powers claims may not be subject to interlocutory review, but there are some that may, and then it goes on to say presidential immunity arising from the separation of powers, citing Clinton against Jones. So Cisneros, I think, expressly contemplates that there be interlocutory jurisdiction in this sort of claim, and that's further reinforced by the court's subsequent decisions in Rose and Rostowski situations where the court said. Indictment, trial, judgment, and punishment according to law.
But
So
that's
right
if you
there,
take the negative inference, correct?
that's the plain language supports that we've heard from the very beginning that it is the language that is the natural and ordinary meaning of the impeachment judgment clause. So that is an argument that is explicit. And I'd also point out that this court in Rose, in Rostowski, in Cisneros expressly held that this is not a magic words requirement. In other words, it isn't that it's got to say right there in the text of the Constitution or a statute that this is a right not to be tried. It's that the right once formulated has to explicitly include the right not to be tried. And that's why what actually the language that's previously in Midland Asphalt is heavily emphasized by Justice Scalia is the situation where there's interlocutory appeal when it's a right, the legal and practical value of which is destroyed if it's not vindicated before trial. There's similar language in Cisneros. And for all these, I'd also point out that the government also has not challenged the court's jurisdiction. It has conceded.
We have to be
absolutely
secured in our own jurisdiction.
Yeah.
Hasn't the Supreme Court itself referred to the Midland asphalt as a suggestion?
I'm not aware of that, but I think
in digital equipment.
Gotcha. Yes, Your Honor. I believe Your Honor is correct about that. I think that's an excellent point, and that's reinforced by this court's case law in Cisneros, Rose, and Rostowski. Turning to the merits, if I may, Your Honor. To authorize the prosecution of a president for his official acts would open a Pandora's box
I know exactly what you're talking about. I made comments to people before on my
How are you?
I just scrolled through the live thing. It seemed like they were taking this cool stuff. I mean, it would make sense for mine, because I want to sell it, so it's quite a distance. I hope they use it. I was kind of worried about next city. You saw I've seen it. This is useless. Is that my shot? Because it was useless, but you know, the whole thing is useless because, yeah. Got up at 5 a.m. today. On the way here, I was talking to my mom before that. I was really curious. Why am I doing this? Are you going to do it twice, or are you going to put the phone? I might have to see twice. Or I can stand next to you. Yeah, four. Yeah, that would make more sense to me. I have a jacket in the car. I'm not bad. Are you sure? Today? Yeah. Yeah, that's to, you know, let me go get our phone. No, I'll get that jacket. If you can, or I can take it with me. Just stay. But I do have a dry coat. Let's go. Can you hold on to it? Just thank you. I'll be back.
Final left. Oh my God, it's so cold. I got the joint.
Thank you.
dry when I got it out of the car. Yeah, I mean, if you want to take it off and put that on, because what's inside is so trapping one inside with that one. Up to you, I think, whatever's fine. And then put it over. Okay. And maybe this is a trick, right? Okay. Alright. Sorry. It's fine. He was saying, I hope they took the shot. I don't know why they didn't. They might have. I don't know. I thought
on whether the acts are ministerial, discretionary, official, private, however you want to characterize it.
I used the phrase from Clinton against Jones, which says purely private conduct is what can be, subject to judicial process after a president leaves office. In response to your question, our principal position is you can look at this indictment and it alleges official acts and it can be ordered to be dismissed. We acknowledge, though, that the district court didn't reach that issue, and Blasingame did remand, and the court absolutely has the discretion to remand to the district court for the application of the doctrine of criminal immunity in the first instance. And we admit that that would be a natural thing for the court to do.
To the specific acts.
Correct. Yeah. In other words, if the court holds that there is presidential immunity, which it should, then remand to the district court to say, okay, go through the indictment and or else hold factual findings and so forth to decide how it applies to the conduct alleged in this case. We acknowledge that would be, the court has the discretion to do that, and that would be a natural course. And if there are no further questions.
I have one more question.
So under the framework established in or discussed in Nixon versus Fitzgerald, we're supposed to conduct a balancing test where we balance the need for the asserted immunity versus other public interests. And I see you as trying to represent a need for the executive to have this immunity to facilitate executive functions, the ability to act without hesitation, to be fearless, to make decisions without being inhibited by the fear of criminal prosecution. But it seems to me that there are some other Article 2 interests here that are countervailing. For example, under Article 2, there's an executive vesting clause. And so there is an interest of the executive branch as an institution to have constitutional vest in a newly elected president. There's also an executive interest as an institution in law enforcement, in enforcing criminal laws. And so it seems to me if we're weighing executive interests versus public interests in things like the integrity of an election, that President Trump's position is not fully aligned with the institutional interests of the executive branch. And in this balancing test, that weakens the executive power that he's trying to assert.
I say three things in response to that. First of all, Nixon against Fitzgerald emphasizes that the most compelling consideration when one considers what it describes as policy considerations rooted in or in the separation of powers is the rendering of the executive branch official unduly cautious in the exercise of highly controversial and sensitive decisions that come up all the time. If a president has to look over his shoulder or her shoulder every time he or she has to make a controversial decision and worry after I leave office, if I go into jail for this, when my political opponents take power, that inevitably dampens the ability of the president.
No, I understand that that's your position, but I guess I'm asking you, what about other Article 2 interests? That's one interest, but there are other Article 2 interests in play here too, and they seem to be countervailing. The interest in executive vesting, the interest in law enforcement, those are also executive branch interests. And how should that affect the analysis?
Those, to the extent the court conducts a balancing, our principal position is you can go back to Marbury versus Madison and adopt a categorical rule, which is also referenced in Nixon against Fitzgerald. But to the extent the court reaches the balancing of policy considerations, those are decisively outweighed by the sort of republic-shattering consequences of subjecting our chief executives in an endless cycle to prosecution once they leave office. The founders were very much against that. They were deeply concerned with that. You see that in Hamilton's writings in Federalist 65, 69, and 77. You see it reflected in Madison's concern about newfangled and artificial treasons in Federalist 47. And that is the original meaning of the Constitution.
I think we should, it just occurred to me, do you think we should take any cognizance of the fact that when they wrote that, George Washington was the president? I mean, a very, very strong executive. The Congress was brand new. Everything else was brand new. And things have balanced out. I mean, we've got a strong Congress, we've got a strong judiciary, and we've got a strong president.
I think that if you look at the writings of the founders, they were definitely looking past the presidency of George Washington, obviously an iconic figure, looking past the presidency of George Washington to future presidencies. And they correctly anticipated that the nation might, what they were deeply concerned about was that the nation would devolve into factions. Factionalism did not govern the presidency of George Washington because of his moral authority. However, immediately when you got to Adams and Jefferson, you immediately devolved into factions. They correctly anticipated and were deliberately looking past that presidency to the future of the republic, a tradition that stood for 234 years until last year when it was shattered by the indictment of President Trump. And if the court has no further questions, we would ask the court to reverse. And if the court rules against us in any respect, we renew our request that the court stay its mandate to allow us to seek further review, both en banc and or Supreme Court review.
And you do have 5 minutes.
Thank you, Your Honor.
We were actually just like
Here.
Good morning, and may it please the court. Never in our nation's history until this case has a president claimed that immunity from criminal prosecution extends beyond his time in office. The president has a unique constitutional role, but he is not above the law. Separation of powers principles, constitutional text, history, precedent, and other immunity doctrines all point to the conclusion that a former president enjoys no immunity from criminal prosecution. At a minimum, this case, in which the defendant is alleged to have conspired to overturn the results of a presidential election, is not the place to recognize some novel form of criminal immunity. Now, I want to start with jurisdiction, as Judge Childs raised. It is our view that the court has and should entertain both claims before it. With respect to the immunity claim, I think this court's decision in Cisneros, 10 years after Midland Asphalt, did allude to a type of separation of powers claim that would involving presidential immunity. I think Judge Henderson pointed out the Supreme Court itself has acknowledged that this idea of an explicit guarantee is more of a suggestion than some sort of statutory prescription.
But there's been no cases since then that have actually used that word suggestion to follow up on that line of thinking.
Within the Supreme Court, I don't believe there have been cases, but certainly this court in Cisneros, as well as in cases also post-Midland Asphalt, like Rose, Rostenkowski, and Durenberger, have recognized that this type of a separation of powers claim, when you're talking about immunity, is something for which a collateral order, appellate jurisdiction on a collateral order theory is available.
And there are also other circuits, I think it's 1st, 2nd, and 10th, that keep following that line of thinking with respect to Midland's Asphalt. It requires an explicit constitutional or statutory language that says you cannot be tried.
So two responses. One, I think in cases like Cisneros, this court has spoken otherwise, but nonetheless, I think the only one there is the First Circuit's decision in Joseph, where it was the case of a judge seeking a criminal, raising an immunity defense to a criminal prosecution. As this court acknowledged in both, I believe, Rostenkowski and Durenberger, that's in some tension with, or it didn't acknowledge that, but the case, the court there talked about Claiborne and Hastings, which are 9th Circuit and 11th Circuit cases. I think Judge Easterbrook, in his shock opinion, noted that when it deals with a personal immunity like that, it's different than the kind of transactional immunities that were considered in the 10th and the 2nd Circuit cases. And at the end of the day, I think we do, so sort of a small point of common ground between us and the defendant. We do think that with respect to jurisdiction, there is a little bit of a different inquiry with respect to a president. We don't think that carries over to the merits in the least. And I think United States versus Nixon is sort of the perfect example of that. There, the court said it would be unseemly to hold the president, to require the president to go into contempt. Nonetheless, reaching the merits, of course, rejected President Nixon's absolute executive privilege claim and required that the...
You don't see a distinction on the civil versus criminal context, because the cases I'm referring to are civil criminal cases.
So I don't, and Rose said as much here when talking about civil and criminal with respect to speech or debate. And again, I mean, I know this Nixon versus Fitzgerald is a civil case, and we strongly disagree that it should be applied here for many of the reasons that Judge Pan set out. But I do think with respect to the immunity, again, given the language in Rose, that would supply basis for this court to entertain the immunity claim.
But now, why aren't you taking the position that we should dismiss this appeal because it's interlocutory? Doesn't that advance your interests?
Our interests are twofold. One, as in United States versus Nixon, it is doing justice. And then the second is indeed to move promptly to satisfy and vindicate the public's and the defendant's interest in a prompt resolution of this trial. But doing justice means getting the law right. And it's our view that even if a dismissal on jurisdiction might move this case faster, actually empirically that's hard to know, we just don't think that's the right analysis here on either immunity or the second claim.
So we have a line of cases, including Kramer versus Gates and American Hospital Association versus Azar. It says that we can assume hypothetical statutory jurisdiction and reach the merits of a case. Statutory jurisdiction being distinct from Article 3 jurisdiction, which we could never assume because that implicates the power of the court to act. So if we had discretion to reach the merits versus just dismissing this case under Midland Asphalt, which I think is a strong precedent which suggests that this appeal is interlocutory and does not fall under the collateral order doctrine. How should we determine how to exercise that jurisdiction about whether or not we should reach the merits?
So I think in the American Hospitals decision, the 2020 decision, the court said the formulation was something like, we're doubtful as to our jurisdiction, but nonetheless, invoking the line of cases you've just described, went on to decide the merits. We would urge the courts to do the same here, even if it entertains doubts with respect to the jurisdiction. Yes, hypothetical statutory jurisdiction is available under the law of the circuit. The court should use that to reach the merits.
But doesn't that lead to a hypothetical decision and an advisory opinion?
No, I think that so we disagree.
The Supreme Court has said that.
No, I don't think the Supreme Court has said that. I mean, the Steele Co. is kind of the leading Supreme Court decision, and then some courts, including this court, has devised a hypothetical statutory jurisdiction doctrine. Now, if this court were to dismiss for lack of jurisdiction and then say, nonetheless, as an alternative holding, here's how we would come out on the merits, that I think would be improper. And that is what I understand the American Oversight Brief to be suggesting at footnote 11 on page 20 of its brief. That I don't think is something the court could do. I understand the hypothetical statutory jurisdiction piece to allow the court to say, you know what, this is hard. There might be arguments on both sides. We think that we assume hypothetical statutory jurisdiction, we move forward, we decide the merits. Now,
let me ask you about Marbury versus Madden. What's your interpretation of its progeny, or even the case itself?
So our interpretation is much closer in line with what I think I heard Judge Pan setting out, and similar to yours. It certainly does not erect a unreviewable power for the presidency. I think the sort of the prime example of that is the Steele-Sheezer case, the Youngstown case. That was President Truman closing the steel mills. That was the court coming in and reviewing that. We see that all the way through to the present. And so it's hard to see any world in which the court just says, we can't intervene here. We do see, I accept the court's, Judge Henderson, the distinction between sort of ministerial and discretionary acts. Compliance with the law is not some sort of discretionary call, right? It is something that I fully endorse or agree with the idea of the paradox of a president, on the one hand, having the Article 2 take care responsibility, and on the other hand, sort of seeing the law as compliance with the law as optional.
Let me switch and ask you, how do we write an opinion that would stop the floodgates? Your predecessors in their OLC opinions recognized that criminal liability would be unavoidably political. So,
a couple of responses. For one, of course, that was with respect to a sitting president. I think the analysis is extraordinarily different with respect to a former president, which OLC in that very same, I'm sorry.
But not with respect to being necessarily political.
Well, I think there is a political process which is impeachment, and we can talk about that, but there is a legal process which is decidedly not political. And that is a process which has the kinds of safeguards that a couple of members of the court here have already referred to. We're talking about prosecutors who follow strict codes and who are presumed to act with regularity, grand jurors, Pettit jury eventually, and this court sort of standing, Article 3 court standing above it. But I also want to push back a little bit against this idea of a floodgate. At least since the Watergate era, 50 years ago, has there been widespread societal recognition, including by presidents and the executive branch, that a former president is subject to criminal prosecution. And Nixon was not about private conduct. Nixon was about, among other things, using the CIA to try to interfere with an FBI investigation. He then accepts a pardon, understanding that after having resigned, right? So again, I think that also undermines this impeachment first argument. After Nixon, we then see a series of independent and special prosecutors investigating a range of different types of conduct. You saw independent counsel Lawrence Walsh in the Iran-Contra affair. That's an example that the defendant invokes in his reply brief. In chapter 27 of that report, the independent counsel
assumes that President Reagan is subject to prosecution and says, but we didn't get there evidentiarily, right? There were not that we thought there was some sort of immunity. And that has continued through to the present. And so this notion that we're all of a sudden going to see a floodgate, I think again, the careful investigations in the Clinton era didn't result in any charges. The fact that this investigation did doesn't reflect that we are going to see a sea change of vindictive tit for tat prosecutions in the future. I think it reflects the fundamentally unprecedented nature of the criminal charges here. Never before has there been allegations that a sitting president has, with private individuals and using the levers of power, sought to fundamentally subvert the democratic republic and the electoral system. And frankly, if that kind of fact pattern arises again, I think it would be awfully scary if there weren't some sort of mechanism by which to reach that criminally.
In your brief, you raised some sort of lesser immunity potentially applying. Want to speak to that?
I do. We don't think that's comes into play here. I think the point was, in some sort of more challenging cases, it might be that where a president is operating under extraordinary time pressure, has to make a very difficult kind of national security type of decision. Do I go in and commit this kind of, do we order the drone strike under these circumstances? A president will often have a cadre of lawyers to advise him or her. The lawyers say, Madam President, we'll get you a memo in 2 months. That's not going to be enough in that situation. If there were a drone strike, civilians were killed, that theoretically could be subject to some sort of prosecution as murder. I think that might be the kind of place in which the court would properly recognize some kind of immunity. But that is, of course, nothing like what we've got here. I sort of take the former official's brief discussing the vesting clause to talk about the kind of the nature of charges when they focus on, again, subverting the electoral process. At a minimum, there should be no type of immunity that covers that.
So are you saying it should be a case-by-case balancing in each case, whether there's immunity, or how does this work as a legal standard?
So we think that it should just be, as the district court held, a finding. There is a balancing under Fitzgerald, right? That's our view. You start with this question: what are the burdens against the presidency, and what are the interests to be furthered? The answer to that question under Fitzgerald, we think that the burdens that my friend talks about on the other side are overstated. I'm happy to describe why. We think the interest in the public's interest in an ongoing criminal prosecution means that there should be an across-the-board rule that a former president is indeed subject to criminal prosecution. What I'm describing in response to Judge Child's questions is, in a particular case, might there be some extraordinary circumstance where a former president could invoke an immunity? Maybe. I don't think the court has to reach that there. I think the court could write an opinion that reserves and says, based on the nature of the allegations, which we take as true, there is no reason to recognize that here. And so I don't think it needs to be a case-by-case analysis, but I think the court can reserve that type of question to the extent it gives one pause about a president in future situations.
To that end, can you answer the question I posed earlier to your opposing counsel about, are we to look at the broader question that was dealt with by Judge Chutkan with respect to presidential immunity, absolute immunity for no criminal prosecution of official acts, versus looking at this indictment and accepting as true the allegations that it brought there, or both?
So we have a strong preference that the court adopts the former view and looks at the question in the way of, as the district court did, which is to say, based on questions of separation of powers, of constitutional text, history, precedent, is there, in fact, immunity for a former president? We think the answer to that is no, for of course, all of the reasons we put in the brief, and I'm happy to sort of address here. Candidly, I think if the court gets to that second question, there are some hard questions about the nature of official acts. And frankly, as I think Judge Pan's hypothetical described, I mean, what kind of world are we living in if, as I understood my friend on the other side to say here, a president orders his SEAL team to assassinate a political rival and resigns, for example, before an impeachment, not a criminal act. President sells a pardon, resigns, or is not impeached, not a crime. I think that is extraordinarily frightening future, and that is the kind of, we're talking about a balancing and a weighing of the interest. I think that should weigh extraordinarily heavily in the court's consideration.
Let me ask you about the effect of Blasingame. What is it? How does it either bind us? How is it persuasive for us?
So I think it formally has no application at all because, of course, very early on in the opinion, the court says we're not dealing with any questions of immunity in the criminal context. I tend to agree with my friend on the other side that in many respects, it does reinforce the nature of the Fitzgerald civil outer perimeter standard. It says you don't look at intent or you don't look at purpose. Context plays a more important role than often the content of communications. I think that the significant change, of course, is the acknowledgement of the looking at a president, whether that president is acting in his or her role as office seeker or office holder. But again, to go back to my response to Judge Childs' question, although that would change the nature of whether may change the nature of whether certain things are or are not official acts in the indictment, we just think that's entirely the wrong paradigm to use. We think under Fitzgerald, in fact, that would be inconsistent with Fitzgerald's reasoning and also just irreconcilable with the nature of how criminal law works. I mean, to say that we're not going to take account of motive or intent, there are plenty of acts that every day. I mean, for example, if I were to encourage someone not to testify at trial because I wanted to go on a hike with that person, it's not a crime. If I were to encourage someone not to go on a hike because their testimony at trial, encourage them to skip their trial testimony because their testimony was going to incriminate me, it's the same underlying act. And now when you map that on to the presidential context, you come up with some of the frightening hypotheticals where as long as something is plausibly official, even if it involves assassinating a prominent critic or a business rival, that would seem to then be exempt potentially from criminal prosecution. We certainly wouldn't concede that if that's the world we need to live in. I think we would advance plenty of arguments below, but we really, but those arguments themselves would create satellite litigation that are an additional reason not to go down this route.
But looking and thinking about your answer about potentially not looking at motive and intent, when there is a criminal prosecution, that mens rea and that intent is part of the actual statute charged criminally.
Yes, precisely. And that's why it wouldn't make sense to then come in and use this non-motive intent. As I understand how Fitzgerald outer perimeter standard might work, it could say those types of official acts, official conduct, that is something from which the president is immune. You don't ever get to that second question of, well, did that person act then with mens rea? Can we prove it beyond a reasonable doubt? Because it is at least under a theory where it's not available at trial, then there's no way to reach that conduct.
When we're looking at this indictment, though, back to Judge Henderson's question about the use of Blasingame, some of the acts are same or similar, and there was direct discussion of it in that opinion as determining whether it was office seeker versus office holder. So do we use Blasingame at least for that?
So if this court decides the case the way the district court did, then I don't think Blasingame has any role to play at all, because there is no question of whether, was this act official or were these sets of allegations official? The question is, based on a Fitzgerald analysis and history, precedent, et cetera, is there any quantum of immunity for a former president? We think the answer to that question is no. There's no reason, as the district court also found, to turn to the indictment and consider this outer perimeter, this civil outer perimeter standard.
How about if we don't decide it the way the district court did?
If you don't, I suppose a lot would...
On the Blasingame.
So there are a lot of different ways this court could not decide it that way. I think to pick up on my response to Judge Childs, we certainly stand by our view in the brief that some substantial number of allegations would fall outside of an outer perimeter, and that I think is enough to affirm. I think either parties are urging the court at that point to then send, of course, the case back to the district court. I think that then would create a series of challenging questions that I mentioned earlier. What are the evidentiary theories under which that evidence could potentially come in? But it would be our strong view, and we would want, if the court followed that route, which we urge the court not to make clear that immunity is an on-off switch, right? This is the immunity appeal. If the court says we affirm, we send it back, there's no immunity, then other things become evidentiary questions or questions really of jury instructions, in which any appeal is then an appeal from a final judgment, if any final judgment.
And the immunity defense is never lost.
Well, I don't think it's immunity at that point. I think this court will, in what I've just described, will have said there is no immunity. There may be some types of other challenges as evidence comes in at trial. But again, I think that would lead to this extraordinarily complicated litigation that is not the top line reason, but certainly among the reasons why the court should not go down that path.
Since President Trump concedes that a president can be criminally prosecuted under some circumstances, he says that that is true only if he is first impeached and convicted by Congress. Do you agree that this appeal largely boils down to whether he's correct in his interpretation of the impeachment judgment clause? That is, if he's correct that the impeachment judgment clause includes this impeachment first rule, then he wins. And if he's wrong, if we think the impeachment judgment clause does not contain an impeachment first rule, then he loses.
So I think that's basically right. I mean, the defendant's theory over the course of this litigation has evolved a bit. And I think now before this court, I understand the argument to be principally sort of the principal submission to be, as you've just described, this, what we call in our brief, the conditioned precedent argument, that there is only liability, criminal liability for a former president if that president has been impeached and convicted. And that is wrong for textual, structural, historical reasons, and a host of practical ones, one of which I'll start with, again, to just amplify the point. It would mean that if a former president engages in assassination, selling pardons, these kinds of things, and then isn't impeached and convicted, there is no accountability for that individual. And that is frightening. Now, to go back to some of the textual and historical and structural, my friend on the other side sort of suggests this is what the founders were talking about and this is what they were worried about. I think that's entirely an inaccurate representation of the founding era history. There's basically no discussion of the impeachment judgment clause, which I take the defendant's principled textual argument to be. What the impeachment judgment clause did was two things, as the district court described, right? It constrained the sanctions that Congress could place on an impeached and convicted officer, not only a president, any kind of officer, to removal or disqualification. And then it made clear that that impeachment did not impose some sort of preclusive bar on subsequent criminal prosecution. You would think that if there was this kind of impeachment first requirement, impeachment and conviction first, you might actually find something somewhere in the sources, the framing, the convention in Philadelphia, the ratification discussions, early history. There is nothing of that. We've cited certain things in our brief from James Wilson, from Edmund Pendleton, from Representative Dana that say this. Justice Story. I don't hear the defendant to offer anything other than, well, Hamilton. All that Hamilton was describing was the undisputed point here that a sitting president can't be subject to criminal prosecution until that sitting president is no longer in office, whether the removal from office is through impeachment and conviction or simply the end of the term. Now, one structural point as well that I just want to quickly make, the district court made this, which is if this rule were right, that would if the conditioned precedent rule were correct, it would pose significant separation of powers problem of its own. It would basically mean that the executive branch would only be able to prosecute someone if Congress had acted. And there are all sorts of reasons why, of course, Congress won't act. For one, they've never believed that it was required. And also, in certain instances, they may decide that they don't have jurisdiction. Many of the members of Congress seem to hold that view with respect to the defendant's second impeachment. Thank you very much.
Go ahead.
Thank you, Your Honor. And in my limited time remaining, I just want to make 3 points to the court in response to the opposing counsel's argument there. One is that the opposing counsel used the phrase above the law, saying that an immunity doctrine for criminal immunity would place the president above the law. I would just direct the court's attention to what the Supreme Court said in Nixon against Fitzgerald in the context of civil immunity. They described the allegation that immunity sets the official above the law as, quote, rhetorically chilling but wholly unjustified. The U.S. Constitution, the separation of powers, the executive vesting clause, the impeachment judgment clause, these are the foundational and fundamental law of our country, and the president's immunity is determined on that. So that is more rhetoric than reality, is what the Supreme Court said in Nixon against Fitzgerald. I'd also point out that when it comes to the question of whether or not the indictment alleges solely official acts, the indictment does not allege that President Trump did anything wrong after he left office. So it focuses solely on acts that he took while he was in office, and that's a telling indication that we're dealing with official acts here. And then finally, I would address Judge Henderson's your question about the floodgates, and I tie that to what my opposing counsel said about a so-called frightening future. The frightening future that he alleges, where presidents are very, very seldom, if ever, prosecuted because they have to be impeached and convicted first, is the one we've lived under for the last 235 years. That's not a frightening future. That's our republic. What he is forecasting is a situation where the floodgates will be opened. We are in a situation where we have the prosecution of the chief political opponent who's winning in every poll, presidential election upcoming next year, and is being prosecuted by the administration that he's seeking to replace. That is the frightening future. That is tailor-made to launch cycles of recrimination that will shake our republic for the future.
If you have the impeachment judgment clause, as you indicate impeachment, then conviction, but then the president either resigns, is removed, and then later on is prosecuted for a different crime. Can that happen, or is there immunity there?
Not sure I understand the hypothetical. Could you say it again? I apologize.
Just indicating that if you're resting on that there must be impeachment and conviction, and it's for one set of crimes, but then later on the president either is removed from office or resigns, and later on there's a prosecution for something different. Is there immunity for that later crime?
Yes, I think that's the better reason. Obviously, it's not presented in this case because we have a close match between the conduct, the underlying conduct or transaction occurrence that's alleged in the articles of impeachment, of which there was an acquittal, right? Which is the strongest case for double jeopardy, and between the facts alleged in the indictment. But if there were like an unrelated prosecution,
you just made a statement about he's only being prosecuted for crimes while in office. And so that's why I'm asking about leaving office and then thereafter being prosecuted for something different.
To be under the plain text of the Constitution, the best reading would be he has to be impeached and convicted for the thing that he subsequently prosecuted. So if he were impeached, convicted, and removed from office, and they charge him with another official act that was unrelated to the impeachment, I think that what Chief Justice Marshall says in Marbury would still govern. I think that's obviously it's not presented in this case. The court doesn't have to decide it, but that'd be my answer.
So I just want to confirm your position is if President Trump had been convicted after his impeachment trial on incitement of insurrection, if he'd been convicted, then this prosecution would be entirely proper.
Which I would say that if he were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. Obviously, we have many other issues with this prosecution.
Is that a yes?
So
because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related conduct as that which is in the indictment.
Yes, I agree with that.
So if he had been convicted by the Senate, then this prosecution would be entirely proper, correct?
Well, I would not phrase it that way because there's lots of other problems with this prosecution that we've raised in extensive pleadings to the district court. He could be prosecuted.
Under the impeachment judgment clause, if he had been convicted by the Senate when he was impeached for incitement of insurrection on same or related conduct as what's in the indictment, then this prosecution would be properly brought.
There's a prosecution could be properly brought. This prosecution, which has tons of other problems with it. I just want to be very clear about that. I'm making any concession that this prosecution is.
All right, let me try one more time. Under your interpretation of the impeachment judgment clause, if President Trump had been convicted when he was previously impeached on same or related conduct as that which is in this indictment, the government could properly prosecute him for that same or related conduct? Yes or no?
Potentially, provided they qualified with all kinds of other legal doctrines that are violated in this case. So I admit that a
I'm
prosecution
only
could
asking
be-
you, under your interpretation of the impeachment judgment clause, is that proper? Is that allowed?
I'm going to stand on my prior answer. I think we're agreeing.
I understand there might be other reasons why you would challenge this prosecution. I'm saying, based on your interpretation of the clause, this prosecution would be properly brought.
Again, I would not say this prosecution, be very clear about that.
But it's a prosecution based on same or related conduct.
This prosecution, which has many other issues related to it, what I would say is that the impeachment judgment clause authorizes the prosecution of a president who's been impeached and convicted by the Senate, which President Trump.
All right, we'll make it a hypothetical. Say a president was impeached and convicted on a charge of incitement of insurrection that is under the same allegations as a criminal indictment. He's convicted. Then the government could bring a prosecution for the same or related conduct, correct?
Don't disagree with that.
Okay.
That's correct.
And then that means that the conduct that's same or related, even if it's official, he could be prosecuted for it, correct?
You're convicted.
Correct. Okay, thank you.
But my question goes to after the fact, and the reason I state that, even though you're challenging that these actions are only occurring while president, the district court's decision was that there is no presidential immunity from prosecution for official acts. It doesn't put a time frame in there. And so that's why I'm going to beyond your investigation, your prosecution might not come until later, after the president has left office. So are you telling us that we are limited to a time frame in answering this question?
I think the time frame is set forth by Chief Justice Marshall against Marbury against Madison when he says never examinable by the courts. So unless there is that one gatekeeping incident that has to occur, which is impeachment and conviction, the official acts, the court has no jurisdiction to review them under the separation of powers and the executive vesting clause.
But that also assumes that an impeachment proceeding occurred. If there is not one, because we discussed earlier that not all officials go through that process.
Absolutely.
That's a judgment call as to whether that process would even be brought.
I would say we have two arguments that reinforce each other. So if there's no impeachment ever and no conviction, then the official acts are immune, period. Further, the impeachment judgment clause incorporates a doctrine of double jeopardy that prohibits it, especially in the case of acquittal. So those are reinforcing doctrines that are set forth in the Constitution. If there are no further questions, we'd ask the court to reverse.
All right, thank you.
Yeah, it's almost as if They should make like super.
Diving out of this stuff.
I got some website Kimi.
Yeah.
I bought some $5 books. One of which is video. They say winds stopper. Instead of wind stopper, it's winds stopper.
Well, wind stoppers only stop one wind.
Yeah.
Winds stoppers.
All.
Stop.
You know what? Still prefer this over the long one.
Really?
Yeah.
You know, I have to agree.
What? The hallway stakeout.
Like speakerphone?
Yeah. Yeah, I'll take this over Longwood.
You said lawyers, you know, I can't see from
Yeah, if he comes out and
could come out later.
yeah. Because I think they used a pull shot from there because it wasn't my shot. It was like somebody zooming in. on that side. So yeah, so I'll just stay here in case, you know, decides to come and talk.
Our cameraman Julio posted that he's expected to speak at Dulles.
Expected to speak?
At Dulles.
At Dulles. Oh, okay.
General aviation signature here.
Yeah, that would make more sense. I mean, why would he come out here while it's raining? So he can, you know, talk. I just told him that because that Liu, I think is low on battery on that side, so I said I'm gonna be up for a bump shot.
Everybody's looking down that way right now. Just leaving right now. Just great guys have got that.
You think I should go?
You're protesting. Yeah. You must be around the other side. You can't walk. I don't think you can walk back here.
Like why? I don't know why.
This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service.
오케이, 오케이. 30, 30. 10時53分に出たっていうふうにメールは来てます。
メールは来てるけど、いや、確認してたけど、いや、よくわかんないけど、わかったら連絡する。
あとはみんな構えてます。出た人は気づいてないので。 You're sure he's gone, right?
Yeah.
All right, man. Thanks.
Definitely gone.
I hope you know you're always my hero.
Yeah, he's been gone for a while. But you know, I'll be gone shortly myself. You need to set up, you can come back. You doing a live hit?
I got a live one.
Yeah. Thank you. I'll be gone.
All right, thanks.
Channel for each thing and decide that we're going to pool. It goes out onto that channel, so everyone who pays into the pool. If you guys pay into the pool, then yes, which I think you do, yeah.
But you can tell, give me a heads up. Who is that? I don't do.
Just FYI, you're on a, everybody is on a hot mic now, so just, and the shot is going out, so just letting it. Okay, that sounds good.
You've got it. I know you do.
I totally do.
We totally got it.
I'm just, you know, I shot football the other day, so it's like I had to change folders over.
Focusing on focusing on.
Okay, can I, is Philip in here? Can I send out that he's coming? Is he here?
Hey, I'm powering on the camera just to put on the power source, and then I'm gonna power up in 30 seconds. Okay? Give me 1 second. I'm gonna stay on the phone with you.
53分に出たっても NBC はもうそれだけですよ。Okay. Alright, thank you. 同じ答えです。出たと思うって聞いて、そうは思わないじゃないですか。どうしよう。入ろう。で、僕の前のやつは AP です。ああ。出たら10いなくなるもんな。変わんないもん。あんま変わんないっす。 ただ、どっかのタイミングで向こうの車線も車一般車バンバン走り出した。確かにそうです。ちょっと反対側見つけましょうか。いや、いい。どうせ行けないから、反対側。まだキツはしてるっぽいですね。
Reminder that we're on the hot mic. Going out to a pool feed. So.
Which? This one? Yeah. Let's make sure we get it.
Yeah. I think we all just asked him, right? I mean, how are you saying? Okay.
Good afternoon. I'd like to make some comments on behalf of President Trump. First of all, this was a momentous day. This is the first time in our nation's history that a sitting president has decided to prosecute his major opponent who's leading in all the polls in the country. The issues that the court had to deal with today were momentous. Whether or not a president of the United States could be prosecuted for carrying out his responsibilities, doing his job as president. We can't have a country where every 4 years there's a cycle of political recrimination, where one administration attacks a prior administration, when in fact that candidate is leading in the polls and will be the next president of the United States. As our legal team, as our appellate team made clear, that would be a disaster for our country. That would be a direct attack on democracy, and that cannot happen. What was very significant today, and I'm sure you all caught it, is the special counsel conceded that if it was President Obama who was being prosecuted for a drone strike, then they'd have to consider immunity. But when it's not, when it's President Trump, then they're taking the position that there's no immunity for presidential acts that were required when a president is carrying out his job responsibilities. If we adopt what the special counsel wants, if we adopt what President Biden wants, then we open the Pandora's box to political prosecution after political prosecution after political prosecution. In fact, Joe Biden could be prosecuted for trying to stop this man from becoming the next president of the United States. We don't need political prosecutions, we need political process. I'd like to introduce President Trump.
Well, I want to thank you all, and we had I thought, very momentous day in terms of what was learned and what they've conceded. They conceded two major points that were right in doing it. I don't think they had much of a choice, but they're very, very big, very powerful points. And I think we're doing very well. I think it's very unfair when a political opponent, is prosecuted by the DOJ, by Biden's DOJ. So they're losing in every poll. They're losing in almost every demographic. Numbers came out today that are really very mind-boggling if you happen to be Joe Biden. And I think they feel this is the way they're going to try and win. And that's not the way it goes. It'll be bedlam in the country. It's a very bad thing. It's a very bad precedent. As we said, it's the opening of a Pandora's box, and that's a very sad thing that's happened with this whole situation. When they talk about threat to democracy, that's your real threat to democracy. And I feel that as a president, you have to have immunity. Very simple. And if you don't, as an example, if this case were lost on immunity, and I did nothing wrong, absolutely nothing wrong. I'm working for the country. And I worked on very hard on voter fraud, because we have to have free elections. We have to have strong borders, we have to have free elections. Those two things almost above all. And we found tremendous voter fraud. We have a list of it. We have some findings if you want it. The press doesn't like reporting it, but we found tremendous voter fraud, determinative voter fraud. But we worked on that. That's what I was doing. And they were talking about after. Well, nothing has to do with after I left. It was during the time. And that was what they really focused on today during the appeal. And they concede that, and everybody concedes that. And if it's during the time, you have absolute immunity. So we'll see how it all works out. We have a great argument. We have an argument with, they conceded two major points today. In fact, I think it's probably a concession. You have to ask the lawyers, Todd, if you'd like to talk about it. But they conceded 2 points that I think were, by normal standards, if it weren't me, that would be the end of this case. But sometimes they look at me differently than they look upon others, and that's very bad for our country. You had a very big event yesterday, as you saw, in Georgia, where the district attorney is totally compromised. The case has to be dropped. They went after, I guess, 18 or 20 people. They wanted to go after a lot of other people. They wanted to go after senators. She was out of her mind. Now it turns out that that case is totally compromised. In fact, they say she's in far more criminal liability than any of the people she's looking at. So I think that when you look at what happened, where they pay a lawyer with absolutely no experience $700,000 who happens to be her lover or her boyfriend, and then they go on trips and vacations together, very expensive vacations together. And the reason they paid him so much, because he was after me, because this way they can afford to pay him a lot more. It probably passes a certain test. And that's a very sad thing that happened in Georgia, and I would imagine that case is going to be dropped. Every legal analyst that I've spoken to, every legal analyst that I've read have said that case is so compromised now it has to be dropped. Very good people were very badly hurt by that case. It's a shame. Very good people. People did nothing wrong. They did nothing different than what Democrats have been doing for years and years and years, whether it's slates or anything else that you're talking about. But they were very hurt, and it turns out that she profited tremendously in that case. It's illegal. What she did is illegal. So we'll let the state handle that. But what a sad situation it is. I want to thank everybody for the fairness. We've been covered very fairly. Most people agree that we're entitled as a president to immunity. If you didn't have immunity, as an example, Joe Biden with the prosecutor, we're not going to give you $1 billion unless you get rid of the prosecutor that's after the company or his son or whoever it is they're after, but he wanted that prosecutor gone, and he's on tape saying it. Or you could say the horrible job he's done at the border where our country is being destroyed, or the horrible situation that took place. The lowest moment, I think, in the history of our country was Afghanistan, the way we withdrew. Not that we withdrew, but the way we withdrew. With shame, we surrendered. People killed, 13 great soldiers killed, many unbelievably, horrifically hurt, wounded, hurt. And hundreds of people died on both sides. Hundreds of people died. He could be prosecuted for that. So you can't have a president without immunity. You have to have, as a president, you have to be able to do your job. But if this didn't work out, if I wasn't given immunity, then other presidents, when we talked about today, President Obama with the drone strikes, which were very bad. They were mistakes, terrible mistakes. You really can't put a president in that position. So I think most people understand it, and we feel very confident that eventually, hopefully at this level, but eventually we win. A president has to have immunity. And the other thing is, I did nothing wrong. We did nothing wrong. The investigation of the election, which was a rigged election, everybody knows it. And if you just look at, they didn't use state legislatures, and they didn't, they went to the FBI, and you look at FBI and Twitter, the Twitter files with the FBI, all of the horrible things, FISA, the FISA court, the signed documents, the lying to Congress, and the stuffing of the ballot boxes, all on tape. Stuffing of ballot boxes, all on tape. Government tape. And most of the information, as you know, we'll give you some of the findings that just came out, but all of that information, as you know, was gotten from mostly government sources, government tapes, government files, and government stats. So it's very sad when something like that happens. You know, you wouldn't have inflation, but much more importantly, you wouldn't have had the Ukraine situation with Russia. You wouldn't have had the attack on Israel. You'd have a much different economy right now. You'd have a great economy, and we would be respected all over the world the way we were just 3 years ago. So I want to thank everybody very much, and we think we had a very good day today. And the concession of these two major points was pretty amazing, and honestly, I'm very glad they did it. I think they did the right thing. Thank you very much.
Mr. President, you just used the word bedlam. Will you tell your supporters now, no matter what, no violence?
I'm with him, so thank you.
Thank you.
Hey, how are you? Sure, why not?
Okay.
Thank you.
Thank you.
Good to see you.
We can come down. We'll come down.
We can power down, we're good?
Yeah, we're good.